In an effort to digitalise the UK border control, the UK has introduced 250 eGates across 15 air and rail ports in the UK, designed to facilitate the smooth, fast and secure entry of travellers. Originally only for British and EU nationals, the use of the eGates has now been extended to Australia, Canada, Japan, New Zealand, Singapore, South Korea and the United States. Nationals of these permitted countries may use the eGates provided that they are at least 18 years old or at least 12 years old accompanied by an adult. They must also have a biometric chipped passport and they must not be travelling to the UK for a purpose which is specifically prohibited by use of the eGates. The eGates are therefore used frequently by visitors and workers under the Tier 2 immigration category. The Home Office estimates that at least 1 million people have used the eGates since July 2019, so it is proving rather popular, but unfortunately travellers and employers need to be aware of the pitfalls when using this automated system. In particular, travellers are not given a stamp in their passport when entering via the eGates. Instead, the Home Office takes an electronic record of the type of immigration permission granted, so the traveller is not given any information whatsoever as to the nature of the permission or the duration. Employers therefore need to be aware that travellers entering using the eGates will be landed as visitors unless they hold current immigration permission on the date of entry. Therefore, if a worker, a Tier 2 migrant, enters the UK before the start date on an entry clearance vignette, they will not be permitted to work in the UK because they will have been entered as visitors. So they cannot lawfully commence employment. This is because the Tier 2 entry clearance vignette needs to be activated during the start and end date of the entry clearance vignette. Migrant workers who enter the UK before their start date, which may be to attend business meetings, for example, are unaware that they are landed as visitors and they think that they will automatically have permission to work in the UK once the start date comes round. Unfortunately, this is not the case, and if they do start work in these circumstances, they will be illegally working. Working in the UK illegally is a criminal offence, and any future application made by someone who commits this offence may be refused. Employers should be undertaking right-to-work checks in the UK of all of their employees to establish a statutory defence against any illegal working, and also to comply with their Tier 2 sponsor duties and obligations. Because of the issue caused with using the eGates, it's really important that employers maintain a record of when their Tier 2 migrants enter the UK. The Home Office requests that a record is maintained and does not specifically require employers to maintain evidence. However, we would advise that employers, if possible, maintain a copy of the traveller's boarding pass or flight ticket to prove that the migrant did in fact enter the UK during the validity of their entry clearance vignette. In the interest of compliance, employers should review their right-to-work processes and their guidance to staff to ensure that their Tier 2 migrant workers do indeed actually have the right to work in the UK, and also to maintain the record-keeping requirements which have been placed upon them as a Tier 2 sponsor.